Although privacy has so many meanings around the world, what is common is they all relate to shared aspects of the human experience. We all as humans need some privacy. Privacy laws around the world are based on widely accepted basic principles, such as limiting collection and only using personal information for purposes for which it was collected. Although I say that knowing that this central tenet is being challenged by the rise and the allures of exploiting big data. There's plenty of common ground that will help pave the way for greater cooperation, even if our different approaches do result in a few bumps on the road. But different historical approaches mean that the architecture of privacy laws also differs. For example, we see differences in how important concepts are defined. What is personal information? What does constitute meaningful consent? We also see variations in the obligations imposed on organizations and also in the scope of national laws. At times, these contrasting doctrines can result in friction, as we have recently seen in the transatlantic back and forth over proposals to update the European Union privacy framework. The EU, as I have said before in other circumstances, leads the way in defining the standards of data protection and in articulating central issues for individuals, such as the right to be forgotten. Hence, it may not be surprising that the draft General Data Protection Regulation apparently ranks, what I read, among the most lobbied legislation ever introduced into the European Parliament. While I can find it often disheartening to watch the sometimes very bitter debate unfold, I remain cautiously optimistic that positive developments for privacy cooperation will ultimately emerge. Seems to me that we in the world outside the United States underestimate the protections for personal information that do exist in the United States. That said, of course, there are some gaps, a situation that a recent New York Times headline referred to as, and I quote, "an American quilt of privacy laws incomplete." If the US adopted comprehensive legislation, for example, along the lines of the proposals in the Obama administration's privacy white paper, it might go a long way to easing some of the current tensions by changing widespread perceptions and by helping those of us outside the US understand what the bottom line really may be. However, we must deal with the reality of the American political system and understand that this may never come to pass. One of the issues I will be following with particular interest is how the EU addresses the issue of adequacy as part of its ongoing review. Those decisions could have an important consequence for countries such as Canada, Israel, and New Zealand, where laws have been deemed adequate, and for countries such as Australia, whose privacy law has not yet been deemed adequate. A committee of the European Parliament has proposed that existing adequacy decisions should be reviewed 2 years after the adoption of the regulation. I believe that before such a review happens, there should be a set of criteria made public after consultation with those countries who have gained adequate status and perhaps with those countries whose claims to adequacy have been rejected, like Australia. Such adequacy criteria should be based on the application of the national law in question and the results of that law's application, rather than the evaluation of the formal legislative wording. A law that looks different than European law, but that has teeth and is regularly and forcefully applied, may, I think, do a better job of protecting the privacy of its citizens than a law that looks good on paper, but lacks meaningful enforcement. The challenge of reaching agreement in the face of different privacy approaches was also evident during discussions to update the OECD guidelines on the protection of privacy and transborder flows of data. That's its formal name. Several weeks ago, I attended, as some other people in the room did, a very difficult OECD meeting to discuss the final possible revisions to the guidelines. As some of you may have heard, there were numerous points of contention, including the concepts of independence of the authorities, references to adequacy, the precise language regarding restrictions on transborder data flows, and mechanisms to promote interoperability. Fortunately, despite our differences and I thought some rather harrowing debates, we were able to find common ground. I was very happy that we resolved our disagreements, as the OECD guidelines remain the only floor-level data protection principles adopted by a range of economies, which are nevertheless free to go farther in data regulation, as the EU has done. And the recommendations in a matter of days will be going to the OECD Council for approval. Let's now turn to a related challenge, dealing with some of the more nuts and bolts issues we come up against when data protection authorities look at working together. We need mechanisms that will allow us to work efficiently, rapidly, to get results at the end of the day. The sluggishness of reaction in the data protection community has not made us more effective, either together or individually. We have problems doing things quickly. When it comes to the mechanics of cooperation, some of the major issues to be addressed relate to information sharing. Some jurisdictions still cannot share information under their legislation. I think this is a serious problem which needs to be addressed. In Canada, our private sector legislation was only very recently amended to allow us to share information with other data protection authorities. And as a result, we've been able to sign bilateral information sharing agreements with 4 European authorities, creating the opportunity to collaborate with our colleagues, the Dutch, on the WhatsApp investigation. And I hope many other future joint investigations. And the Irish Data Protection Commissioner, for those of you who were here at the end of the day, yesterday, Billy Hawkes mentioned our current joint investigation of the most recent Facebook data breach. Coordination is another issue. If a privacy issue affects multiple jurisdictions, we need to figure out how to coordinate the response across the globe. I know EU regulators are talking about this, but the problem becomes infinitely more complex when you're doing this across the globe in many, many different time zones. Do you appoint a lead data protection authority? If so, how involved should other jurisdictions be in an investigation as it proceeds? And more often, we are dealing with the communications challenge of explaining to your country's citizens that another nation will take the lead on a major privacy issues. These are not minor obstacles.